Now I would request Honorable Dr. Lalit Bhasin to honor Shri R. Venkataramani, the Attorney General of India, with us as our chief guest. Ladies and gentlemen, please have a huge round of applause for Shri R. Venkataramani. He is a distinguished legal luminary with an illustrious career in the field of law. Known for his profound expertise to justice, he stands as a guardian of legal principles, contributing significantly to the legal landscape of the nation. Ladies and gentlemen, Shri R. Venkataramani, the Attorney General of India, with us as our chief guest. Let's have a huge round of applause, everyone. Sir, can we have a few words from your end, please?
You see, Mr. Venkataramani is much beyond being the Attorney General of this country. He is a great scholar, a great jurist, a great academician whose first love is legal education. And he's devoted so much of his time to promote and strengthen the legal education system along with the legend, late Professor Madhav Menon. Therefore, please put your hands together to give a great to Mr. Venkataramani. Attorney General's position is the only constitutional position for any professionals in our Constitution. That shows, you see, the significance of the legal profession, which has been recognized by having a position like that of Attorney General, being a lawyer, read with Article 22 of the Constitution, which says that every accused will be entitled to have legal assistant, legal profession. So that is the significance of our profession, the only profession which is recognized in our Constitution. And Mr. Venkataramani is the constitutional head of the legal fraternity of this country. Big hand.
When Mr. Lalit Bhasin invited me to speak in this wonderful congregation, I had some reservations. Firstly, let me say that I have no claim to have any greater knowledge or experience than any one of you. And secondly, to be in the midst of a very unique set of people, unique in more than one sense, and to have the courage to share one little knowledge and experience, I think maybe sometimes open to question. Nevertheless, Lalit Bhasin is a great organizer and a wonderful organizer. He can bring people from all over the world and gather them on matters of common concern. And I thank him for asking me to be part of this evening today. My regards and respect to the honorable judges of the Supreme Court, Justice Bindal and Justice Pankaj Mittal. And as we try to engage oneself in the unveiling of what Supreme Court has been trying to do by opening up its e-windows in more than one sense and more than one way, I think they are part of that very enterprising engagement. And as people of my generation who have not only grayed in hair but also crossed certain ages of learning quickly, but the Supreme Court doesn't leave us in that kind of repose. And so we almost every day use our iPads for learning, arguing, knowing, interacting, and also doing a bit of game work. So it's a wonderful journey for many of us now. Having said that, to greet a confluence of special sets of legal fraternity is a great pleasure. Special sets in the sense of a class of legal talent who are closer to the world of challenges and problems than the distant participants like us, who are the sound and fury of the legal profession. The class of legal talent who are here are integral to the motions of law and justice in a more fundamental way, and of no less in importance and accomplishment than the visible players in courts and tribunals. The forum LexTalk World, as they gather, seems to be gathering momentum year after year, and I wish it becomes a world-class congregation. I say no, not only because of patriotic reasons, but from a deep sense of the need for perennial engagement of larger segments of the legal fraternity and the community also, in promotion of values of fairness, equal regard, and a vigil and attention in harnessing technology and its use for enhancement of human welfare. More than 30 years ago, students from Max Planck Institute in Munich, dressed as white mice, protested outside the European Patent Office and canvassing that there shall be no patent on life. This happened in the context of issue of an application to patent the so-called Harvard onco mouse that was genetically engineered to serve as a test animal for cancer research. Well, the US Patent Office had cleared the patent. In Europe, the commercial exploitation was to be scanned under principles of public order and morality. Utilitarian understanding, however, became the watchword for relation to genetically modified plants and then to copies of human genome sequence that calls for a muscle relaxant. Moral objections to patentability were kept aside. The web of issues relating to technology now virtually run through all aspects of technology, from crime detection and investigation to health welfare, to communications, to transportation, use of natural resources, and to justice administration as well. The engine of creation in each one of us, I repeat, the engine of creation in each one of us, which is so fundamental to human flourishing and elimination of social disparities, can receive its best host primarily in private engagement innovations, which emanate when private curiosity and freedoms mingle. While governmental engagement in certain areas such as defense or cyber security are non-negotiable, creativity demands freedom. The challenge, however, is creativity for what? Creativity for mere personal or unregulated commercial considerations? Creativity blind to sustainability? Creativity which can render us as victims or slaves to technology? These are questions that will ask all of us to be in constant debate. We cannot be a world without minds, and the balance between being mindful and progressive may not admit of simple solutions. Forums such as LexTalk will be platforms for meeting of minds from different ends of the professional spectrum to generate socially relevant frameworks or principles. This will be the future of legal debates. Writing about the new challenges in genetic engineering, the British philosopher Mary Vankataraman said, I quote, "Technology has made all kinds of things possible that were impossible or unimaginable in an earlier age. Ought all these things to be carried into practice? These are the most general ethical question to be asked about genetic engineering, whether of plants, animals, or humans. The question may itself take two forms. In the first place, we may ask whether the benefits promised by the practice are outweighed by its possible harms. This is an ethical question posed in strictly utilitarian form. It entails looking into the future, calculating probabilities, and of course, evaluating outcomes. Benefits and harm are not self-evidently identifiable values. Secondly, we may ask whether even the benefits of the practice seem to outweigh the dangers, it nevertheless so outrages our sense of justice or of rights or of human decency that it should be prohibited whatever the advantages. I quote. Technological disruption, as it is now talked about, can silently alter the foundations of societies. The holy grail of technology, as Rajiv Malhotra says, is artificial intelligence. Charles Darwin might have winked at his proposition of survival of the fittest if called upon to assess the expanding frontiers of artificial intelligence. Mr. Malhotra seems right in talking about the following battles vis-à-vis artificial intelligence. 1. Battle for economic development and jobs. Battle for power in the New World Order. Battle for psychological control of desires and agency. Finally, battle for the metaphysics of the self and its ethics. Battle for India's future. These are very important battles, and I do not know whether one can have an outline of all these battles by artificial intelligence itself. These are important heads of debates. We cannot, as responsible members of legal fraternity, remain as mere passive consumers of debates. Our active engagements will bring the necessary balancing elements. I consider evenings like this and congregations like this are such balancing elements. We are equally concerned with the administration of justice. While we talk about expedition in dispute resolution, dispute resolutions are becoming complex and caught in many procedural webs. We are still far away from simple and inexpensive dispute resolutions. The world of tribunals and their functioning are riddled with issues, primarily due to management lapses. Every special task tribunal is caught in administrative and human resource deployment issues. Then the use of tribunals such as NCLT to matters not originally designed to apply, namely real estate resolutions, or the wide net of money laundering, etc., call for urgent attention. As I said, private initiatives in all walks of life are indispensable. A fully regulated state has been shown to be unworkable. At the same time, global thoughts on the failure of the free market in not being able to address elimination of economic inequalities and the gaps in governmental ability to deal with unemployment and other forms of deprivation are matters of undeniable importance. Each one of you here represent the face of private initiatives in industry, commerce, and new forms of public services, and each one are building blocks of a free society. In 2007, the New York Times Magazine featured a long article gushing about how historians of the future will look back on the 1990s at the time when neuroscience began to transform the American legal system. The article described how new brain scan technology and how this will eventually answer the elusive questions of just what are our deeply shared beliefs upon which the legal system should be based. Brain scan imaging and the information it reveals are indeed marvelous. Nevertheless, it is said that the excitement over law and neuroscience has not led us to great hopes. Perhaps the same can be said about every aspect of marriage between science, technology, and law. If only science could give us categories or something to measure, or if you could find the right configuration of experts, law's problems would probably dissolve. But it is not to be so. When we borrow structures from science, the adaptive process breaks down, and it does so for several reasons. The most obvious reason is that we do not understand the science we're importing and applying very often. As a result, we do not allow law to evolve in a very effective and a nuanced fashion. We are always in a hurry. We have learned that there are no ultimate doctrinal structures in law because there are no ultimate questions asked so far. But we reach a stage when we begin to ask very ultimate questions about what law can do in the face of what humans are doing in the rest of our lives. The two fields seem to be divided in one sense, but they are united in a fundamental sense. So today, if technology has begun to open many issues within itself, how do you find regulatory principles outside technology? Or do we locate regulatory principles within technology and science themselves? They're very important questions that I think we need to understand and grapple with them as we move ahead with technology virtually occupying every aspect of our life from morning till evening. We open up our day with WhatsApp and we end our day with WhatsApp. But if it's going to be so, if the use of technology for ease of life, the use of technology for bringing about elimination of inequalities on the one hand, on the other hand, the use of technology that can lead us in many ways beyond what we can imagine is a big question to be asked. And therefore, the ability to law to enter in very important areas of life in the past has been slow and probably not the adaptive method. We only looked at laws of contract in a very restrictive domestic sense. We looked at international law, again from narrow domestic senses. The Cold War, after the Cold War, we had the breakdown of Soviet Russia. And today we no longer live in that area. Our commons is called the knowledge commons, but it becomes part of the world. I mean, no country and no nation can say the knowledge commons belong to us. Nothing belongs to any nation or any people whatsoever. Everything belongs to all of us. If everything belongs to all of us, knowledge commons, I think, is the fundamental thing where we bring about important changes to eliminate inequalities. And if we do so through use of law and science, I think that will be the greatest wonder that we can pat ourselves on our back. When constitutions began to look at domestic problems, they had very narrow ideas. Each constitution looked at its own nation as a unit in isolation. But today, we cannot look at it like that. So we need to have not only resources commons, but also knowledge commons. And knowledge commons can come only we break down all barriers within us. And that's where perhaps the knowledge commons in law will probably take us as quickly as possible into a world where the resources commons will be shared by each and every one of us. And I think today, when people say that the knowledge commons cannot be shared, we live in an antiquated world. The knowledge commons must be shared. One very well-known American academic, Jeremy Waldron, picked up a very important idea from a Roman jurist and said people in ancient trade, Roman, they went to Rome to trade, but they carried with themselves their own part of the law. So we all have our own part of the law, but there are certain principles that are common to all humankind. So we've reached a stage when many principles, which will have to be necessarily become common to all humankind, will take over what's called the dark area of our bronze and iron ages of history. So we need to go into a golden area where these dark areas will have to probably stay away. And how do you go about doing that? And it's a very important challenge. And it is not merely stated and then answers will not come like a jukebox. Answers will come only by constant engagement, constant deliberation, and more of deliberations and thought processes. As in this context, I think kind of congregation like this make enormous sense. We need to probably have more and more platforms of enduring value and vibrant importance. So let's create as many platforms as possible where we swear to ourselves that the resources commons and the knowledge commons, which are driven by fundamental principles of fairness, equality, and equal regard, will be the future of our legal fraternity. I think all of us can do that. And let me once again thank Mr. Lalit Basin for giving this very important evening opportunity for me, and let us continue to share our thoughts and values towards moving a fair society. Thank you so much for your attention.